Started. My name is Jordan Shapiro, and I'm with the San Francisco Foundation and its initiative, Partnership for the Bay's Future. We're so glad to be hosting today's event, Empowering Tenants, a training on the Tenant Power Toolkit, where we'll learn how this tool supports tenants in fighting eviction, asserting their rights, and connecting with legal and organizing support. You can explore the toolkit yourself at tenantpowertoolkit.org. I'm going to go ahead and put that link in the chat. Oops, wrong link. Just a couple of quick notes before we jump in. This event is being recorded and we'll be sharing it afterwards. If you'd like to be notified when the recording is available or want to stay updated on future events, news, and resources, please sign up for our email list at basefuture.org. I'm putting that link in the chat as well. We'll also have time for a Q&A at the end of today's webinar. Please submit your questions using the Q&A box, not the chat, to submit your questions so we can be sure to catch them. Now, I have the pleasure of introducing today's panelists. Renee Christian Moya is an organizer with the Debt Collective and the Los Angeles Tenants Union. He is a former campaign director for the Proposition 21 campaign in 2020, a ballot initiative to strengthen rent control in California, and has worked extensively on tenant rights, local rent control campaigns, pandemic-era emergency protections, and social housing. Cherry Mulaguru is a supervising attorney in the Inner City Law Center's Tenant Defense Project. She has been doing eviction defense work since 2018 and has worked on unlawful detainer cases in California since 2020. She began working on the Tenant Power Toolkit in 2022 and now leads the legal development and e-filing work done by ICLC for the toolkit. Paul Lankto is the senior software engineer at the Debt Collective. He developed the Tenant Power Toolkit along with various web and mobile applications over his 10-year career. He is also an organizer in the Los Angeles Tenants Union. Rose Lenahan is a tenant organizer for the Debt Collective, where she focuses on supporting unrepresented tenants facing eviction who have used the Tenant Power Toolkit and on organizing tenants of large corporate landlords, especially against predatory utilities billing. She also organizes with the LA Tenants Union. She previously taught philosophy. And with that, I'll hand it over to Renee.
Thank you so much, Jordan, and thank you everyone for being here today. I'm very sorry, my cat just jumped on my lap right now, so he wants all of my attention at the wrong moment. Again, thank you, Jordan, for having us. My name is Renee Moya. I'm the project coordinator for the Tenant Power Toolkit. It really is my job to try to bring together the three disparate teams that make up the Tenant Power Toolkit. Those teams being a kind of small tenant support team, our tech team, as well as our legal arm, our legal folks at the Inner City Law Center, as well as to work to expand the partnerships that we have going across the state. I'm going to share my screen now, folks, to walk through a presentation, and then we'll pass it off to my colleagues to walk through other bits of it. A little bit by way of introduction, the Tenant Power Toolkit is an initiative of the Debt Collective, the LA Tenants Union, the UCLA Luskin Institute on Inequality and Democracy, as well as the Anti-Eviction Mapping Project. However, there have been many, many other organizations across the state that have at different points in time supported the work of the Tenant Power Toolkit in various ways. To name a few, the Alliance of Californians for Community Empowerment, and its legal arm that then span off and became a separate legal service provider, Movement Legal Services. These organizations provided us a lot of information, a lot of support on existing statewide protections for tenants in other jurisdictions. We also, of course, have been working hand in glove with the Inner City Law Center from the very beginning, and organizations such as the Housing Now Coalition and Tenants Together as well. So what is the Tenant Power Toolkit? The Tenant Power Toolkit is a set of legal mutual aid tools that allow California tenants to A, prepare an answer to a summons and complaint in an eviction lawsuit, and B, to be able to respond to a request for admissions. We'll explain a little bit what both of these things are through the presentation. Tenants respond to a series of questions that the toolkit poses to them about their eviction, as well as about their living situation, And using the answers that tenants prepare, we basically use that information to create the strongest possible answer for a tenant in their eviction case. Why did we build the Tenant Power Toolkit? Gary Blasey, a former professor at UCLA Law, a longtime social justice advocate, once described the failure to respond to a court summons in an eviction as the secret tripwire in the eviction process. If a tenant fails to file an answer, they will be evicted automatically. And in fact, it was initially the information that Gary Blasey put together in a report for UCLA in 2020 that was the impetus for the creation of the Tenant Power Toolkit. This idea that tenants were failing at the first hurdle in their eviction because, again, they couldn't file some paperwork. Tenants in California have 10 days to respond to a summons and complaint, or they can lose their eviction cases through a default judgment. What that means basically is that if a tenant isn't contesting the merits of their eviction in an answer, then again, the court will very often, almost universally, will rule against the tenant and say, this hasn't been contested, and the tenant will lose their case in that way. One thing about the 10-day deadline is that historically, for many, many years, the tenants only had about 5 days to respond to an eviction, which is quite ridiculous, given the fact that the answer is meant to be a kind of a legal document with a lot of information about a lot of complicated information about the tenant's defenses, and yet, of course, the state system basically required tenants to be able to respond within those 5 days. That has recently changed as of January of this year to 10 days. Although I would, if I had to give a little bit of comment on that, would say that that is still not enough. During the pandemic, at the height of the pandemic, actually, the state had changed that deadline from 5 days to 15 days before bringing it back to 5 days. Now we have 10. The toolkit raises comprehensive defenses to mount a strong case for tenants. We don't think it's enough for an answer prepared by our toolkit to basically just give the bare bones defenses that a tenant would need, or just to treat the answering of the summons and complaint as enough. And so a lot of the work that went into building this toolkit was to ensure that tenants could have a comprehensive set of defenses, and those defenses being founded on both state law as well as local law, right? County protections, city protections, which we can talk about a little bit today. We also created the Tenant Power Toolkit, though, because we believed that the data that we can collect using this toolkit can help organize or power organizing locally and statewide. We have been able to gather a wealth of information from our database, which I'll share in a bit, that gives us a lot of information about who is getting evicted, who is doing the evicting, what are the reasons for these evictions, and the like. This, we believe, as our database grows and use of the toolkit grows, can become a very powerful arm in the advocacy for better protections for tenants statewide. So how does the toolkit work? Any tenant with access to an internet-ready device, a laptop, or even a mobile phone, can use the toolkit to answer a series of questions about their eviction case. The tool then prepares all of the documents needed to file an answer to the complaint and other essential legal papers. And again, like I've said already, invokes a battery of defenses under the use it or lose it principle. Once the answer is filed, a tenant has time to find help. I want to say just two things. The use it or lose it principle, by that we mean that if tenants don't invoke as many of their defenses as possible in an answer, they really do risk not being able to use those defenses at trial. And so again, it's a reason why we insisted basically on creating a tool that did that, that raised these defenses. Okay. I think for those of you who are in the legal services profession, I'm not going to belabor the point about the eviction process. For those, though, who do not know much about evictions, it's really important to understand that the eviction process is, number one, a process. It's not just a one-off thing that happens to tenants. It really is kind of a multi-stage process itself. And that process can be a little bit long and complicated. In short, if I had to kind of give you a little bit of a run through of the eviction process, normally what happens is that a tenant gets a 3-day notice, a 15-day notice, 30-day notice, a 60-day notice, or a 90-day notice from their landlord asking them to move out of their homes. The landlord must issue this notice in a written form. Verbal notices are not valid. We also know that a text message or a phone call is not enough to be able to say that I've properly notified you that I want you to leave your house, right? This notice, by the way, is not, and we should be very clear, is not the actual summons and complaint, right? It's not, it doesn't mean that a legal eviction case has been filed against the tenant. It really is the landlord saying, hey, you have 3 days to do something, or we are going to move to evict you through the court process. So examples of this, for example, might be a 3-day notice to pay or quit. So when a tenant, for example, doesn't pay their rent on time, the landlord can give you a 3-day notice saying you have 3 days to be able to pay that rent now before we actually push you out. It could be a 3-day notice, for example, to do something, to perform or quit. That could mean something like you need to stop, creating a nuisance in the building. You should stop, making too much noise in the building, what have you. It could be a different form of a request, but it's still a request nonetheless. That if unsatisfied, the landlord can go to the court to file an eviction case against you. After the time period that the notice is for, so 3 days, 15 days, 30 days, what have you, and if the landlord believes that the tenant hasn't yet satisfied the requirements, right, set down in the notice, then the landlord can move to evict the tenant through the court process. And so what happens is that the tenant will receive a summons and complaint that they will be served that basically lets them know that they have an eviction lawsuit, against them. I should also add that at the very least in LA County, tenants also receive a courtesy letter from the court prior to getting served by the summons and complaint that basically lets them know from the courthouse that they do have a pending lawsuit against them, an eviction lawsuit against them, but that in and of itself is not the summons and complaint. In short, what happens if the tenant doesn't respond to the summons and complaint is that the process moves very quickly. And again, the tenant has basically already put themselves at risk of losing their homes. What happens is that the landlord will basically go to the judge, or will go to the court, and they will file a request to enter a default, right? A default judgment. The judgment will be entered in favor of the landlord. The judge is going to say, yep, the tenant didn't respond, so they're not contesting this, this eviction. After this process, the landlord can basically go and apply for essentially for a writ from the sheriff's department. The tenant will receive a sheriff's 5-day notice, basically, that basically says to the tenant that they have 5 days to leave before the sheriff comes to their house. And then, of course, the sheriff will come to their house and evict them after the completion of that 5-day notice. What happens there, like in terms of the timing, can really much depend on how many people are getting evicted at any given point in time. 2 things that are important to note, or just one real thing to note here, is that there are, of course, moments in this process, even after a tenant didn't answer, where tenants can try to receive or try to intervene on an emergency basis to try to prevent this process from resulting in an eviction. In our experience, though, that's very difficult. It's very laborious. One requires a lawyer, obviously, to be able to go through that process. And of course, a lot of times, I'd say even the majority of the times, the tenant doesn't succeed in doing so. So this is why it's important for the answer to be prepared. Okay, before I actually go through a quick run through of the Tenant Power Toolkit, I'd like to share some data that we've actually learned from the toolkit and its use over the past few years. The upshot is that the Tenant Power Toolkit has helped thousands of tenants to be able to prevent a default judgment. So far, as of the end of April, we've had about 16,113 answers that have been prepared by the toolkit since it was launched in July of 2022. And an average of 524 answers have been filed every single month since the beginning of 2025. Of course, if we look at the census figures, we know that the average renter household in California has about 2.7 people living in it overall. And so because of that, we know that an estimated 41,000 to 43,000 people overall have benefited from use of the toolkit. And mind you, that Census Bureau number has been borne out by our own data within the toolkit. We ask people to identify how many people live in their household who are either adults or children under the age of 18. And literally that number comes to about 2.7, just like the Census Bureau data. So the Census Bureau is pretty accurate on that. 13,000 of the 43,000 people affected have been children. And in overall, the 16,000 cases that we've had or answers that we've prepared, 40% of those answers involved a household with a child. Now, so far, the vast majority of our data has been in LA County. About 86.1% of all of our users are in LA County. Although, again, that does mean that there have been tenants who have filed their answers with the Tenant Power Toolkit outside of LA County as well. We know that the biggest reason why tenants are getting evicted is because of non-payment of rent. In May of 2025 alone, 86.1% of all cases that were filed with the toolkit were for non-payment of rent. We are able to glean from this information, by the way, also the average rent that tenants are paying, right? The median rent. And so over the past, or since January of this year until now, the average tenant getting evicted through the Tenant Power Toolkit has responded in the toolkit saying that they have or are paying rent of about $1,916 on average. That is a slight bump, I should say, from the 2024 figure, which itself had been kind of a slight dip or a plateauing of the monthly rent number from 2023. So again, we're starting to see kind of like average rents increase, at least within the Tenant Power Toolkit. And the average tenant who is getting evicted says that they have, on average, something like $4,300 worth of rent debt to their landlord. So in general, for eviction cases this year, the average rate of non-payment cases is about 81% of cases. So again, the reason why most tenants are getting evicted is because they can't pay their rent. But in 8.6% of cases, the tenants are being pushed out because of a no-fault eviction. A no-fault eviction includes things like, for example, an owner move-in, right? When the owner says that they're going to move themselves in or their family members. In those cases, they make up about 8.6% of all of our users. And in 1.2% of all of our cases, which are part of the no-fault number, by the way, in 1.2% of cases, tenants are reporting that they're being evicted because of the Ellis Act, which basically allows landlords to remove housing units from the rental housing market, really as a way of circumventing rent control. Who are the tenants getting evicted? 38.4% of tenants who are being evicted are reporting that they are Latinx or Hispanic, but a kind of whopping 32.3% of all users of the Tenant Power Toolkit are Black. White folks make up 18.1%, Asian folks 4.8%, and so on. These are self-reported numbers, and of course, some people are basically responding using or claiming multiple identities, and so this number does not round up to 100%. But again, that does kind of show the overwhelming number of people who are being evicted are people of color. And to really kind of emphasize this, we also know that the tenants who are being evicted they tend to be kind of lower income. And so 95.8% of the people who are using the toolkit right now are fee waiver eligible. And 17.3% of tenants who are using the toolkit have basically said that they have requested a special accommodation from their landlord for disability purposes. So about 1 out of every 6 users is reporting, some kind of a disability. 60.9% of all users are currently receiving Medi-Cal. So it doesn't mean that they qualify for Medi-Cal. They basically say that they are receiving Medi-Cal already. And 43.1% of all of our users are currently receiving food stamps. Now, in terms of habitability, right, bad conditions, the upshot here is that about 1 out of every 6 tenants reports that they are not having any sort of habitability issues in their building. They're not invoking any defenses for habitability, but that means nearly 85% of tenants basically are currently reporting some form of a problem with their habitability issues or conditions in their building. The primary reason for complaints in our toolkit for habitability are for plumbing. So 52.2% of all Tenant Power Toolkit users say that they have basically experienced plumbing issues. 51.5% of people say that they have suffered from pests, things like rats and roaches and bed bugs, etc. 44.3% of tenants say that they are experiencing leaks. 39.3% have mold. 37.8% say that they have peeling paint. 36.8% say that there are issues of security in their building and or other unit, right? So things like the doors not closing properly, locks not working, etc. And I really want to emphasize from this data the kind of radical disproportionality of the impact of eviction on Black renters in California. In our toolkit, again, about a third, or roughly a little bit more than a third of all users are Black, despite the fact that California only has about 8.7% of its renters being Black. In LA County, that number is slightly higher, so 9.4% of all renters in Los Angeles County are Black, but still that is a massively, disproportionate number given the number of renters in California who are Black. And the important thing about this, by the way, is that Black tenants are being evicted both in communities where we would not expect. So in other words, they might be living in buildings that are located in areas that are overwhelmingly Latino, overwhelmingly white, and yet the people who are being evicted in our data, at least, the majority or many of them are going to be Black folks. And the important thing also about this, the second thing, is that corporate landlords are the ones who are driving this problem forward. And so in November of 2023, for example, we had been looking back at the data over the previous year and a half of Tenant Power Toolkit use. And what we realized was that for the four of the five biggest landlords in the entire country, Equity Residential, for example, 59.3% of the tenants who were using the Tenant Power Toolkit and were being evicted by Equity Residential were Black. For Essex Property Trust, it was 58.1% of the people that they were evicting and using the Tenant Power Toolkit were Black. For Avalon Bay, that number was 43.7%. And for Invitation Homes, one of the largest single-family home rental landlords, that rate was about 41.7%. So again, that rate of kind of radical disproportionality of evictions affecting Black people, the corporate landlords even had an even more inflated number in that regard. Okay, I gave a lot of data. I gave a little bit of information about the toolkit. I'm going to briefly walk through the toolkit. This is not a full training. We have trainings every single month for folks who want to see a comprehensive walkthrough of the Tenant Power Toolkit. What this is going to be about really is showing you elements of the Tenant Power Toolkit and our website that are kind of important to understand and that will allow you to kind of explore on your own after this presentation. We really hope you folks go and do that after the fact. So I want to start by mentioning again our homepage, our website. Jordan mentioned it at the top of the call. That is tenantpowertoolkit.org. And I want to start by basically pointing out two very important sections of our homepage on our website. The first thing that's really important to note is that the links to our tools, to both the answer tool that allows tenants to prepare an answer, as well as to the requests for admissions tool, both of those links are actually found on the homepage. And so when you go to tenantpowertoolkit.org, you're going to scroll down and you will eventually find a section that looks like the screen grab on the left here, right? The one that we're going to kind of walk through the most right now is the answer tool, right? The one that prepares answers to an eviction. And what will happen is when a tenant gets to that section of the toolkit and they want to start an answer, they will go to the bottom left-hand corner of that screen grab, that picture, where it says start your defense. The tenant will click that button and a separate page will open with the actual tool itself, where they can start answering questions and prepare an answer. In the same way, if a tenant wants to prepare a request for admissions, an answer to that, they will click the button that says start your response. Of course, if tenants want to learn more information, they can click on those buttons as well. The second really important section of our homepage is right below this part where the links are located, and that is information about our workshops. So at the moment, and my colleague Rose will talk a little bit more about this, at the moment we have a series of both workshops online and in person that tenants and advocates can make use of. The two that I'm highlighting on this screen grab on the right, though, are, I think, the most important for tenants themselves. We have an eviction response workshop currently only in LA, but very soon going to be starting in the Bay Area in the East Bay. The workshops are in person because this is a place for tenants really who have no access to an electronic device or who don't feel comfortable with an electronic device or have language access issues. They can go to one of our 2 workshops in LA. One of them now is located in Pico Union in kind of central Los Angeles. And the other one is located at the LA Law Library in downtown LA, right across the street from the central courthouse. And at that workshop, they can get support from pro bono lawyers and volunteers who can help them walk through the Tenant Power Toolkit so that they can understand the questions that are being asked, etc. The other workshop that we have is an online tenants' rights workshop that my colleague Rose and another colleague who is not on this call today, Areli, run, one in English twice a month and one in Spanish twice a month. These workshops really are to walk tenants through not so much their legal rights, the way that tenants' rights workshops often work, but really contextualizing it within the eviction process. So the tenants who are being impacted by an eviction at that point can kind of know what to expect as they are moving through the eviction process itself. We wanted to make it practical and not just informational in that way. The other 3 really important pages on our website that I wanted to point out. Number 1 are the FAQs, are frequently asked questions. I think this is the most important page after the homepage because here we have a wealth of information answering tons of questions that come up regularly about the toolkit. But also, and importantly, here on this section, you can actually find the guide that allows tenants to be able to self-file their own paperwork. We will talk about this in a bit, but basically the Tenant Power Toolkit does allow tenants to electronically file their paperwork through the court system, thanks to the support of the Inner City Law Center. They will talk a little bit more about this later. But for a large number of our tenants, they can't qualify for e-filing, either because they live outside of LA County or because even in LA County, they don't qualify for an automatic fee waiver. And so for all of those tenants, our Tenant Power Toolkit still works. You can still prepare all of your paperwork. The difference is the tenant has to go and submit the paperwork themselves at the courthouse, and they need to serve their landlord. And so our FAQs gives you a guide, a very comprehensive guide on how you do that. So again, the FAQs are the next important page there. The next important page after that, I think, is the next steps page, which is kind of a little bit of a guide on what to expect after you as a tenant file your answer. And so we really try to provide some basic information about what to expect after you filed, to, for example, not ignore your mail because you will receive discovery oftentimes, etc. And so it's important for tenants to know that. We try to give that basic information so that tenants don't feel like they don't know kind of what to expect after they filed an answer. And then finally, we have a Get Help page that has some links for tenants. At the moment, the information is a little bit more comprehensive for San Francisco County and for Los Angeles County. We do give some information about tenant unions, especially, for example, ACE, the Alliance of Californians for Community Empowerment, outside of LA and San Francisco. But this information is a little bit basic at the moment, in part because, again, we would have to build an entire database of tenant union support, legal service provision, etc., locally to be able to do that. We do, though, link to the legal aid search database provided by LSC, the Legal Services Corporation, that basically allows you to find your local legal aid office across California. Though we do note for tenants that oftentimes legal aid is not going to be able to help you in your area. We do say to tenants that they should at least ask the legal aid office locally to them to see if there are other law firms that might be able to help them. And we also, of course, point out the fact that legal aid will not probably be able to help tenants if they are undocumented. But again, to ask for a list of referrals so that they can actually find the legal support that they need. Okay, now, what about the use of the tool itself? Like I said before, the link to the tool themselves are on the homepage. A tenant then will start by going to the homepage, click the button, start your defense, and then the toolkit will open. This is what the very first page of the Tenant Power Toolkit looks like. And I'm using it here because I want to point out a couple of things that are very important. The first one is that the Tenant Power Toolkit is now in 7 different written scripts, right, or languages. English, Spanish, Korean, Armenian, Filipino, as well as Chinese, both simplified and traditional. This has been kind of a labor of love over the last, kind of year to make this happen. And thanks to the support of the Legal Aid Foundation of LA and Stay Housed LA, we were able to actually make this happen. So that is the first thing. You will be able to select the languages that you need to be able to then proceed with the rest of the Tenant Power Toolkit. Every page on the Tenant Power Toolkit will have the following basic items. So the first thing that you see highlighted here at the top is a toolbar that basically just lets you see, it's a progress bar that lets you see where you are in the process of filing an eviction answer. So right now we're in the welcome section. You probably can't tell because the green is a little bit dark, but it is green for welcome. The other elements of the progress bar are in black. You see that after you move from the welcome section, you will move on to basic information. Basic information is where the tenant will basically put in information about themselves, their contact information, the name of their landlord, their name and address, etc. All of the information that we need to just know who they are, how we can get a hold of them will be answered in that section. The section after that is information from your documents, where the tenant will look at their summons and complaint, the paperwork they got from the court, and start plugging in that information into the toolkit. After that, they will proceed to the defenses to eviction section. So they will be asked a lot of questions about where they live, what are the conditions in their apartment, etc., to be able to build their defenses. Then after that, the tenant will have the opportunity to basically request a jury trial, as well as to prepare fee waivers for their court fees. And then finally, we'll take them to next steps, where we prepare their documentation and we let them know kind of what to expect after they are done. Another thing I want to point out is the second item highlighted at the bottom. Every single page of the Tenant Power Toolkit, the toolkit itself, comes with audio narration. We did this for accessibility purposes. And so if you want to click on that toolbar, it will basically read back to the tenant whatever is kind of in that page or on that page at any given moment. I'm really glad that was something that we were able to build in quite early on to the toolkit itself. And then finally, there are arrows on the top right-hand corner and the bottom left-hand corner. We always tell tenants that they can create an account with the TPT. And that account, by the way, the only thing we ask for is a username and password to be created. And the purpose of that account is only so that the tenant can save their place on an incomplete answer. Tech issues happen. Your computer might blow up. The internet might cut off. Your child might set fire to something in the kitchen. The worst thing you could possibly do, because the Tenant Power Toolkit can take anywhere from 40 minutes to an hour to respond to, or even longer, depending on the tenant, the worst thing in the world would be for suddenly you to lose all of that information halfway, and you had no way of being able to save it, right? So this is why we created this opportunity for tenants to do that. And frankly, it's worked very well in the past. It has helped me in the past when I've been preparing or helping a tenant prepare an answer. We are able to then kind of log back in and make sure to continue on from there. The important thing about how the Tenant Power Toolkit works is that the questions in the toolkit will be a combination of questions about the tenant and their living situation. So like the left-hand screen, they will type in a lot of information about themselves that really only they will know, right? As well as questions where the tenant is being asked to pull information from the summons and complaint. And of course, what we try to do throughout is to make it easy for people to know what it is exactly that we're asking them to do, right? And so again, we will say, look at this section on your your summons and complaint, plug in the information that is listed there exactly as it is listed in the paperwork. So it is really kind of this combination of responses that allows us to be able to generate an answer. The toolkit does make understanding formal legal documents clear and intuitive, right? So the questions that need direct answers from the paperwork itself will include pictures like the ones you see here on the screen right now that explain exactly the part in the paperwork that they need to be able to pull from. And so as an example, on the left-hand side, it says notice to defendant, and then it will list the name of the tenant next to it We're telling the tenant, look at what it says there and put in the information exactly as it says it on the paperwork. And we mean exactly, right? So for example, in that section in particular, oftentimes landlords will make spelling mistakes or they will otherwise mistake the name of the tenant. And the tenant tries to rectify that directly on their own. We say, no, no, no. Whatever it says there directly, plug that information in first, and then we give the tenant the opportunity to kind of correct their name in a follow-up question. But again, we do try to guide tenants in a very blunt way, saying, see the information on this page, drop it in into this question right now, exactly as it is listed. The toolkit does help people prepare answers no matter what kind of paperwork a landlord uses to file the eviction, right? The unlawful detainment. We know that most landlords will oftentimes use the image on the left-hand side that you can see there, which is the form complaints, which it looks like a checkbox, right? Or a list of checkboxes that a landlord will fill out. That is the most common use of the paperwork or the paperwork that we see. But we did, about a year and a half ago, notice that there were landlords who used the paperwork that looks like the one on the right-hand side, what we call pleading papers. And so in response to that, the Tenant Power Toolkit, because we heard from users in the Central Valley and the Bay Area, we basically refactored the toolkit somewhat to allow for us to be able to prepare an answer for UDs that looked like the documents on the right-hand side. So again, we are constantly trying to build in flexibility to make the toolkit as useful as possible to tenants statewide. We do also allow tenants to file amended answers in their case. After a tenant files a first answer to their eviction paperwork, we know that tenants might make mistakes, or as is often the case, they will go to, for example, a self-help desk that will allow them to basically prepare an answer with just general denials where they don't actually, invoke any of their specific, eviction defenses. And so for that reason, we basically say to tenants, like, look, if you want a second shot at this, you can actually come back with us and you can prepare an amended answer in the toolkit. So we think that that's been a very useful thing for tenants in those cases. Again, after a tenant prepares an answer, they have about 10 days to be able to file an amended answer. We do also try to ensure that the Tenant Power Toolkit is, kind of invoking defenses for tenants statewide. And so for that reason, we do ask a series of questions looking at the paperwork itself to determine what jurisdiction the tenant actually lives in, where they are getting evicted. And in that way, we are able to determine the defenses that apply to the tenant in those cases. Final slide, I think, at the moment for myself, and then I'm going to pass it to my colleague, Cherry. I want to say a little bit about defenses themselves. About a third of the toolkit's questions are about defenses. So again, the toolkit does allow tenants to be able to raise their defenses that they can then use at trial or in front of a judge. And we are able to do that by asking the tenant very plain language questions about their defenses. So on the right-hand side, what you could see is questions asking the tenant, like, look, do you have any of these issues in your building, right? Like habitability conditions. So for example, do they have holes in their walls, floor or carpet that you, the tenant, did not cause? Have you had any problems with enough hot water? Do you have rats, roaches, bed bugs, etc.? We make it easy for tenants to be able to identify those problems themselves and to then, kind of raise those defenses for habitability. It's important to note that while defenses can be raised in the answer, but ultimately not raised during the case, a defense not noted in the answer cannot be raised later. So again, just to kind of explain this once again, if the tenant is not invoking as many of the defenses that apply to them in their case as possible in the answer, that is something that they're very likely not going to be able to use at trial later. And so it's very important, and this is why we really go through the defenses applicable to the tenant in this section to really ensure that they're getting those protections. And the defenses that we look at are, I think, fairly comprehensive. We look at defenses for habitability, right, from state law. We look at defenses for deficient notices. So for example, where let's say that the landlord gave a tenant an incorrect notice, that is not the reason, or it is not aligned with the reason stated in the eviction for their eviction, or they never even give them a notice before just proceeding directly to the legal process. So deficient notices are a defense in our toolkit that we prepare or we raise. We raise questions around retaliation. We also raise defenses, for example, for disability accommodations, for harassment, for domestic violence. We also obviously raise defenses for local and state protections. Those protections look like the Tenant Protection Act of 2019, a law that applies to most tenants across the state, and that basically caps the rent roughly at the highest level of 10% per year, as well as some protections on eviction. And of course, local defenses, such as local rent stabilization laws like LA, San Francisco, Oakland, Berkeley, you have it. And of course, just cause protections, which basically limit the reasons why a landlord can evict a tenant. We do work very hard to ensure that the moment that a new state law is passed that expands tenant protections, or that a new city applies for, or rather adopts rent control or just cause, we make sure to plug in that law's defenses into our toolkit as early as is possible. We make sure to do that thanks to the support of organizations like the Inner City Law Center, as well as Movement Legal Services. And of course, we also work with our partners at the Western Center on Law and Poverty to make sure that we are being kept up to speed with any local protections that are being passed, so that we do prepare a comprehensive answer. And the final steps in the toolkit, after you have answered all of these questions about your situation, the defenses that apply to you, the next step is a tenant gets to invoke their constitutional right to a jury trial. In California, we do have a constitutional right to a jury trial. And so the toolkit does tell tenants that they have this right and they should invoke it. The toolkit also allows tenants to apply to 3 different types of fee waivers. 2 of them are automatic fee waivers. That is for tenants who are currently receiving public benefits and or who qualify because they are low income. And 1 discretionary fee waiver, basically where they don't automatically qualify for one of those 2 fee waivers, but they can say to the court, look, I pay too much on my medical bills. I pay too much on medication. I pay too much on my child's schooling. Please give us a fee waiver in my case, even though, again, we don't currently have public benefits or do not qualify for low income. In Los Angeles County, if a tenant qualifies for one of the 2 automatic fee waivers, then that means that it gives them also the opportunity to have their paperwork electronically filed by our team, which means that the tenant doesn't have to go to the court or doesn't have to serve the landlord. Our team will take care of basically filing the paperwork electronically. We also give tenants at that stage in the process, at the end, the option, if they qualify, so if they're in LA County and if they qualify for an automatic fee waiver, to e-file their paperwork. And then finally, we do basically allow tenants, a couple of things happen. 1, you get a page similar to the one you see on the right that allows tenants to download their documents immediately after they're prepared. That's to ensure that the tenant, in case there's an electronic, there's a tech error, they can download their paperwork right then and there on the toolkit when they're still using it. And it gives you some information about what to do next. But we also email all of the paperwork that is attached to your answer. So again, the tenant will receive that if they reach this stage of the process. Okay, we're going to try to hold on questions as much as possible because we want to be able to give you all of this information. And so to continue with the presentation, I'm going to hand the controls over to my colleague, Cherry. Cherry, take it away.
Thank you. Hi, everyone. My name is Cherry. I am a supervising attorney at Inner City Law Center. And I'm just going to reiterate a little bit the main points that Renee just made, and specifically focus on what the toolkit can and can't do, just to start out. So, the main thing to note is the toolkit does, the answer tool specifically, does generate documents based on tenant responses. So Renee touched on this. The toolkit asks tenants to pull information from the documents that they got, like the plaintiff's name, And then it asks tenants questions that relate to defenses that will then populate. Those boxes will get checked based on tenant responses in the answer. So those questions are plain language. For example, if we're in the Tenant Protection Act section, the tenant is not asked, does the Tenant Protection Act apply to you? They're asked if the unit was built within the last 15 years, and other eligibility questions like that. And then you might get, if you're a tenant with a fault case, you would be asked, did you receive a separate notice, giving you the chance to stop or correct the issue before you got the notice telling you to leave? Um, so, based on how the tenant responds to all of those questions, the toolkit generates an answer, obviously the most important document here. And then the toolkit also generates the fee waiver, jury demand, and proof of service, which is what Renee has already talked about. We do still have the UD 104, obviously, so that is the COVID-19 declaration. Those are really, really rare these days, and we'll be pulling it from the tool, I believe when the statute fully expires later this year. But for now, the UD 104 does still get generated by the tool. And then, as Renee has mentioned, we can e-file for those in LA County if they're at least 1 day from their filing deadline, and if they qualify for an automatic fee waiver, not a discretionary one. The reason we do need that 1 day for the filing deadline is from the filing deadline is, you know, some tenants might assume that the tool is kind of just automatically sending things to the court, but as I'm going to talk about in a little bit, what it really is that we have a team at ICLC that looks over the paperwork, not for the accuracy of the defenses, but just to make sure that it won't be rejected, for example, if the plaintiff name is wrong. And we file it, and we don't really have capacity to be getting same day filings at 2 p.m., and uh, the tenant will be better off in those instances filing themselves, since we do see about 30 to 40 filings a day, on the higher end. Okay. And as Renee also mentioned, I do just want to emphasize one more time, the toolkit is usable by everyone, even those who do not qualify for electronic filing. And we provide step-by-step, checkbox filing instructions when you finish the toolkit in the email that you get and on the FAQ. And one other thing to note is an answer can be amended once as a right within 10 days of the first answer being filed. The toolkit does also do amended answers. It's one of the first questions that you're asked. Next slide, please. Thank you. Okay. Equally important, what the toolkit cannot do, the tenant needs the summons and complaint, not the notice of UD that Renee mentioned. They need the summons and complaint to be able to use the toolkit. They will be pulling information from there. The answer is a response to the complaint. They will need the information that's in there. They'll need the notice to quit that's attached and so on. They'll need to see if a notice to quit is attached even. So we do always want to make sure that tenants have summons and complaints with them when they are going through the tool in their hand. The toolkit does not work for commercial units, different set of defenses. It's just not going to raise the defenses that a commercial tenant might have. It does not assist tenants who've already got a sheriff's notice to vacate. Renee talked a little bit about the eviction process, but once a tenant has lost the case, either they lost based on the merits, or quote unquote based on the merits, in that they lost at a trial, or maybe a motion was filed, a motion for summary judgment or something like that, or they lost by default, by missing their answer deadline or missing a trial date or hearing. In either case, once a judgment is entered against all of the tenants in the case, the landlord gets a writ of possession. They can take that to the sheriff's department, and the sheriff posts a notice to vacate. That is the only legal way to lock someone out in California. You cannot do a self-help eviction. It's illegal. So once this notice to vacate is served on or is posted on the door, a tenant gets 5 days to vacate, and the sheriff can come anytime after that. The issue here is that a judgment has already entered against the tenant, so there's no way to file an answer at this point. They need to do a motion to set aside. So the toolkit will not work for someone who has a notice to vacate from the sheriff's department. Sometimes tenants only find out about cases at this stage, so there can be some confusion there. Um, the toolkit does not provide legal advice or representation. Sometimes tenants can be confused about that. We only provide this limited service of the answer tool and potentially electronic filing in LA County. And we do have a couple of waivers in the tool to make it clear to tenants that that's the limit of the service that's being provided. Um, and the last thing to note is it does not generate an answer for tenants who are not named in the lawsuit. The main reason is if you are part of a law firm, you know that when you're electronically filing, you like select a defendant and then select the paperwork that they're filing. We need a tenant to file a prejudgment claim. And then once they're added to the case, they will show up on the list for electronic filing. Um, and uh and then we'll be able to file for them. So the tenants who are not named in the case but do live in the unit and want to fight the eviction, they need to add themselves with a prejudgment claim of right to possession, and then they can do their answer. Yeah, next slide, please. Okay. And one important thing to note about fee waivers, Renee already touched on these, that the toolkit creates them. The toolkit will create both of these fee waivers. The first, FW001, is for waiving all court fees. There are all different kinds of court fees. Even filing an answer costs $225 or more, depending where you are. And if you don't get your court fees waived, you'll have to pay that. You'll have to pay to file anything in the future. You have to pay $150 for a jury trial. So it is important that a tenant, complete the fee waiver section of the tool as well. Yeah. And I think we can move on to the next slide. Okay, one thing that we have not touched on is that we do have another tool in the toolkit, not just the answer tool. We noticed that the toolkit launched in 2022. It allowed tenants to respond to eviction cases, many times tenants who might have defaulted. And in part because of that, in part because of the rise of generative AI, more and more landlords have been serving requests for admission, which is a discovery, which is a type of discovery on tenants. And that is just another way that a tenant can kind of lose the case automatically, right? Much in the same way that not filing an answer in time can lead you to lose the case automatically, no matter, even if you have the best defenses in the world, you can still lose your case just for not filing your answer in time. Similarly, if you don't respond to your RFAs, if the landlord's lawyer serves requests for admission on you, and you don't respond in time, they can file a motion in court to have all of those requests for admission deemed admitted. So for example, the landlord will send requests for admission that say, admit that the landlord did nothing wrong, admit that you have no defenses, admit, XYZ. And having all of those deemed admitted means now you have no grounds to fight your eviction. The landlord can file a motion for summary judgment and win the case. So we recognize that, it's really important to make it more feasible for tenants to respond at least to the requests for admission that they might get, just so that they don't get caught on this next hurdle. So the request for admission tool is also available on the Tenant Power Toolkit website. It's available in Spanish and English, and it kind of works similarly to the answer tool. Tenants fill in info from their paperwork. We give them examples of how to respond, and then the tool takes them question by question. It asks, how many RFAs did you get? And it goes through each one. The tenant selects objections and answers each question. Like the answer tool, it relies on tenant responses. It just makes the process more navigable for tenants. Tenants can often be really overwhelmed fairly by getting discovery responses. So we do treat different objections differently. So if the tenant selects an objection like this is asking me about my immigration status, the next page of the tool where the tenant will select their answer will say, because this is asking you about confidential information, you can choose do not respond or no response. Um, and then, so there is, guidance that's provided to the tenant there. It is shorter and simpler than the answer tool, but like I said, it does still just rely on tenant responses. And since RFAs are not the only type of discovery that a tenant can get, we link to a bunch of other resources, including templates for the other types of discovery and remind tenants to complete those as well. It's just not the same kind of, automatic loss hurdle. So we did prioritize the RFA tool first. Next slide, please. Okay, I am going to touch very briefly on how we electronically file for tenants in LA County. We've mentioned to you a couple of times that tenants in LA County can have us electronically file their paperwork. And what that really means is when a tenant goes through the whole tool, selects to have us e-file, they qualify for that, they get the option to have us e-file, they choose for us to, and then they agree to an additional waiver. The documents that are generated are automatically sent to ICLC. And we have a team of admin clerks, and I'll talk a little bit more about our staffing as well, but we have a team of admin clerks who review the documents to make sure that those will be accepted. So, they'll check things like, is the fee waiver completed properly? Is all the case information accurate? Is the case number accurate on the documents? And we do not screen or, speak to the tenants about the defenses that are raised themselves. We do not, admin clerks are not attorneys. They do not provide that legal advice. The admin clerks will then complete the proof of service, then file the paperwork, and they will serve the landlord's attorneys. We do that electronically, and an attorney does have to accept electronic service, but as the server, you have to confirm that that's the right address for electronic service. We are a law firm that does eviction cases in LA, so we maintain a list. Even when an attorney doesn't provide an email address, we often have their e-service address anyway. And then if the landlord is pro per, we will serve them by mail, print and mail the documents via the post office. Once the documents are accepted, we do also send the conformed copies to the tenant so that they can keep those for their records. If there are rejections, we will address those. If we see that a tenant already has a judgment against them, we will call the tenant, we will send them resources to do a motion to set aside. And we do all of this, we track the status using a backend that we have for the toolkit so that we can make sure that nobody falls through the cracks. Our staff does speak with tenants. Sometimes we'll see a case, for example, where the tenant's name is different on the paperwork and in the e-filing system. So the court system has a different name for the tenant than what the tenant gave the toolkit. In those instances, we don't want to assume what the tenant's correct name is. So we would call the tenant to confirm, edit the documents as needed. But like I said, no legal advice is given. And then one final note is we do not represent tenants, even tenants in LA County. Tenants in LA County are directed to Stay Housed LA. So the Tenant Power Toolkit team does not directly provide further legal representation or assistance to toolkit users. We only provide this e-filing and service and electronic or mail service service to the tenants. That is mainly also done so that we can keep ICLC's eviction defense work and ICLC's Tenant Power Toolkit work distinct. We do not want tenants to be confused. We do not want to mislead tenants about, whether we're representing them in their case. So the Tenant Power Toolkit users, we do not screen them for legal representation. In LA County, we have Stay Housed LA, which is kind of this like overarching project that most of the orgs that do eviction defense work get their cases through. Next slide, please. And then one last slide from me. This is our staffing for doing the work that we do on the Tenant Power Toolkit. Like I said, we can handle 40 or more, slightly more, electronic filings each day. Typically we don't get 40 every day. You know, we'll have more on Mondays because they build up over the weekend. But I'd say on average we get about 25 to 30 per day. And those are handled by 6 admin clerks. But it's really equivalent to 3 full-time admin clerks because our admin clerks also do our full scope referral processing on the other side for our team. So they only devote 50% of their time to the Tenant Power Toolkit and e-filing. So it's really just 3 people able to handle up to 40 or more referrals per day. I mean, e-filings per day. We also have a project coordinator. She is primarily responsible for tracking all of our incoming e-filings, making sure that things don't fall through the cracks, handling any overflow beyond our admin clerk capacity. They assign the e-filings to each admin clerk. They will handle any rejections. They handle training our admin clerks and other things for our team as well. But it is important to have somebody who can kind of oversee the whole process and make sure that you didn't miss an email or we didn't get an email for somebody who did complete the tool. And then we do have some other TPT staff. We have a volunteer and outreach coordinator who runs our eviction response workshops. You can see a flyer there for them. And then I am the supervising attorney on the team, and we have a staff attorney as well because ICLC also handles the legal development for the tool. We update the tool with any legal changes, we do testing and so on. And that's it from me.
Hi all. I'm Paul. I'm with the Deck Collective as well here for the Tenant Power Toolkit, and I do the web development for the tool as well as our various tools that we have, along with a small development team on our end. So yeah, I wanted to talk a little bit just about our general data collection and kind of future updates we're making to the e-filing process on our end. So you can see here kind of 2 screenshots from a little bit of our back end. So basically everyone that submits a response, every tenant that goes through the toolkit, um, once they get to the end step where it generates their documents, it will send an email to them and to our e-filing team if they opted for e-filing and qualified, with their documents and with some information on next steps. It will also create a database entry that we can see on our end. We use this, our admin clerks use this to help manage what documents they've sent to court and for which defendants, also to contact them if there's an issue with their filing or with anything that they filled out in the documents. But here you can see that basically every entry we have, there's in this second screenshot on the lower part of the screen, it includes not only data about, contact information, where they live, um, their names, etc., but also all of the defenses they selected. So not only are these generated on the documents, but we actually have this codified in data as well, so that we can query based on it to see, what percentage of people filing have mold in their units, for instance. And so in this screenshot, it's like habitability E, habitability F, but that all that is in reference to is the habitability defenses for point E on the documents, and that might correlate to mold or to broken windows or things like that. So we store this data on our servers securely. We don't share this data with anyone outside of our internal team for data analysis and really aggregated data analysis, or with the ICLC team so that they can do the actual filings. We do have an option that tenants can select at the end of the tool, uh, that if they would like to be contacted by supporting organizations, tenant organizations, um, things like that, and so they can consent to being followed up with. We'll follow up with them ourselves often, to invite them to our trainings, and workshops for next steps in the process, things like that. But we also have the ability if organizations want, to support in this process, to also be referring tenants uh, directly to them, and providing contact information, assuming we set up a data sharing agreement and what that might be used for, because the tenants consented to receiving that support. Our data is also, we store it on a backend that is only accessible by user accounts, so that we assign user accounts to our admin clerks so that this is secure and uh, can't be accessed outside of this. And yeah, I guess if you can go to the next slide, Renee. One thing too that we do with this data, like I mentioned, that we're aggregating it. You saw some of it at the beginning of the slide here, when Renee was giving his presentation, but we're also working on a web dashboard uh, that will have kind of aggregated uh, data visualization, that a user could go through, anyone could go through to this website. It's still a work in progress, but we're hoping to have it up here soon. But based on the data we've gotten, things like the top 10 biggest evictors across California, we've already identified some of these actors like Avalon Bay or Equity Residential, as well as also seeing in what parts of the state and of LA County, where we have a lot of our users, where these evictions are happening, kind of in heat map styles. So that's something that we're planning on working on in the future. And we have this data already, and we have a lot of great uh, visualizations that Alex, one of our team members that works on the data, has already generated. But we want to make this more publicly accessible so people can kind of see this data themselves. Um, and then I think the last slide for me is really talking about a custom electronic filing app that we're developing. So not only do we have this suite of different tools that help tenants file responses to an eviction, to the request for admission process, but also we want to help streamline uh, the e-filing for our legal team as well. There's kind of a lot of the software that's out there is very clunky. It can take times. I'm sure if you work at a firm and you have an e-filing capability with whatever software, this can be a very laborious process and very tedious, and filling out a lot of repeat sections. And so I think they estimate it can take like 30 minutes to do a filing. And so we want to really streamline that, especially because we already have a lot of the data we collected from the tenant filling out this tool. So we're working on uh, our own e-filing app that connects through the InfoTrack One Legal software, that we've been granted access to kind of do this ourselves, with the team over there. Um, but yeah, so basically here you can see two screenshots where you can search for a case number. It will then pull up all of the relevant details for that case, such as who's the plaintiff, who are all of the named defendants, have the defendants filed an answer. That's a key thing, that in a lot of these softwares, you can't see that the defendant has even filed an answer until you go through the whole process and file the answer yourself. And then you learn that it was redundant and you didn't need to do that. So we're trying to kind of put that at the forefront. Um, and then once you select a defendant, you can, in our tool, upload their documents, and we're building it out to automate a lot of the data filing, or data filling, uh, such as like the defendant's names and the addresses, as well as what the documents are for, what kind of type of document it is, what the fee waivers they have, and then to be able to really just e-file that so that the process is more about reviewing the documents and making sure that everything is good and less dealing with software to file it. So that's something we'll be rolling out hopefully in the next couple of months for our team at Inner City Law Center, but also any legal teams across the state that want to work with us. We're able to give access to that software as well for kind of a streamlined process to help with e-filing here. But yeah.
Great. Hi, everyone. My name is Rose Lenahan. I also work at the Debt Collective, and I'll just talk a little bit about the structure that we have in place to support people after they've used the toolkit, and basically make sure they get where they need to go in order to get more support. So we have weekly workshops, as Cherry mentioned, that are held twice a week in person at 2 different libraries in central Los Angeles. And tenants can go there to get help with using the toolkit. We've tried to make the toolkit as simple as possible, but ultimately someone is creating a legal document and there's a huge amount of information to go through. And a lot of people who are facing eviction need more support than that. Whether because they have literacy issues, they have language barrier issues, they don't have, ability to access the internet easily, they have trouble using technology, etc. So we have those in-person workshops, which are twice a week. We also have online workshops, which happen every week, twice a month in Spanish and twice a month in English, where we talk about next steps for the toolkit. So after a tenant uses the toolkit, they will receive an email as well as a text message inviting them to these online workshops. I do the ones in English and my colleague Aurelie does the ones in Spanish. And at those workshops, we basically explain the eviction process. We explain the way that the answer fits into that process. A lot of what we try to do is emphasize that the answer is just one step in the process. And so if a tenant is going to get the outcome they need, whether that's to stay in their home, whether that's to be connected to rental assistance resources, whether it's to find legal representation so they can fight their case all the way to the end, they need to do a lot of other things beyond just filing the answer. So at that workshop, we explain how the answer fits into everything and the next kinds of documents that people might get. For example, if they're going to get discovery requests, what that might look like and what steps they need to take to respond to discovery. If they're going to get a piece of paper in the mail that has a trial date, what that means and what kind of documentation they need to have prepared for that date and what they should expect at that date. We also send text messages to tenants who need to self-file. So we e-file for a lot of people, but for some tenants, we can't e-file, and so they need to file everything themselves. And that is there's many steps to that. So we need to remind people to do that and just check in that that's been done. And we have support via email and voicemail and phone. So I respond to email questions that people have after they attend the workshops, and Aurelie responds to phone calls for situations that come up as people are trying to file or right after if there's been some issue or they have some question about filing. Next slide. Then there's also the question of what broader kind of support to do beyond that. And I'll say a bit about what I do, but I think as we try to expand the toolkit across the state, we need to think about the way that the toolkit can connect to all of these other resources, and all these organizations can work together to make sure that people are getting connected to the resources they need. So I think the way that the toolkit directly affects the outcomes that tenants have depends tremendously on the ability of tenants to get legal representation later on. So we emphasize that once the tenant has done the toolkit, they have an answer, and that does something very important for them, which is it prevents them from getting a default judgment. So we know that it won't be the case that they'll have an eviction on their record, that they'll have all this rent debt and a court judgment against them that they're going to owe, and that the sheriff's going to come to their door. We've prevented that from happening automatically. But there's many other outcomes. People can lose their cases much later on down the line. They can lose their cases because they didn't respond to discovery. They can lose their cases because they didn't go to court. They can lose their cases because they didn't know how to prepare their paperwork. They can lose their case even if they prepare for jury trial, because representing yourself at jury trial without a lawyer is extremely difficult, especially if it's not in your native language. So for tenants who aren't able to connect to legal representation, I think a lot of those tenants are able to successfully settle their cases early on in the eviction process. They go to court their first trial date. Maybe they don't have very strong defenses. Maybe they weren't able to find free legal help. Hopefully they have somewhere they can go if they can just get a little bit of time. And then they can negotiate to make sure that the case is sealed so that they don't have an eviction on their record. Hopefully they can negotiate around any rent debt that they owe to make sure that that won't burden them going forward. And hopefully they can get some time to move out and to find a new place. We hope that tenants can get much more support beyond that. And again, that depends on what infrastructure is kind of available beyond that. So in LA County, we're lucky that there's Stay Housed LA, which provides free legal representation to some tenants, depending on zip code. And then there's also an organization called the Eviction Defense Network that provides a pretty comprehensive training program for tenants who don't have legal representation. A lot of what I do in my role is make sure that the most vulnerable tenants get to one of those places. So imagine that there's a tenant who doesn't speak English, who comes to one of the workshops that we have downtown to do an answer. That tenant is going to, after that point, still receive legal documents in English. And so they're not going to understand exactly what step of the process they're at, or what paperwork they need to fill out, or how to find legal help that's trustworthy. Unfortunately, there's a lot of scam lawyers and bad actors who will exploit people's stress and fear about the situation to charge them a ton of money and do a very bad job. So a lot of what I will do is try to look out for people who I think might need a little bit more support, and make sure that they get to the organization they need to get to. And sometimes I'll go to court with them and stand by their side, while they're in their initial conversations with the landlord lawyer to make sure that that they don't get screwed over, basically. So I think, ideally there would be enough staff and infrastructure to ensure that that could happen for every tenant. The scale of the eviction crisis right now is so enormous that the staffing needs would be huge to really do that. But I think as we keep developing the toolkit and as we keep building more relationships, and as we expand to other places in the state, ensuring that all those connections are made and that there's a clear process for people after they use the toolkit will be really important. And I think the toolkit can be integrated in a really helpful way into any other eviction defense infrastructure that exists. Though I know that in some places there is very little. In the Bay, I think there's a lot that could be well integrated. One of the things the toolkit can do that's really important is simply to buy tenants more time. So the tenant in the picture here, his name is Roberto. He speaks Spanish. He was being evicted in the kind of case that is so frustrating to see, that we see all the time, where the landlord was just trying to get him out of a rent stabilized unit. So his rent is way below market. And so the landlord basically refused to accept his rent, and then lied and said that he hadn't paid rent. And so eventually he was able to connect with more legal help, but the toolkit allowed him to buy the time and file an answer on time so that so that he didn't get a default judgment and he could kind of use that extra week or extra 2 weeks to do intake at another legal organization that could help him. I think, yeah, I think that's all I have for today. So thanks so much. And I think now we're going to Q&A.
Before we do that, actually quickly, Jordan, since we do have a little bit of extra time, and thank you so much, Rose, for that. Thank you so much, Paul and Cherry. I just wanted to say a couple of things that I didn't think we were going to have time to kind of address, but we do. Just on the scale of the problem, I just wanted to really highlight the fact that this is or has been historically an enormous problem for tenants statewide. By some estimates, somewhere between 400,000 to 450,000 tenants, like individual people, are impacted by an unlawful detainer lawsuit. It depends on a given year, but it's roughly 400 to 450,000 people. And the important thing about that is that historically, in about half of those cases, tenants have lost their cases automatically because they never responded to an eviction paperwork. So again, we're talking about 250,000 people who are getting their records destroyed, who are getting evicted through the legal process because they simply did not know how to file an answer. And as Rose said, filing an answer buys you time. It buys you time to be able to find a lawyer. It also just simply buys you time to negotiate with your landlord so that you can drop the case and move out even, right? Without destroying your credit record, without having a legal, a mark on your legal record, what have you. I think it's important to emphasize that over and over again, because it's for that reason that we've wanted the Tenant Power Toolkit to expand beyond LA County as much as possible, and why we need Bay Area partners to do that. The other thing to mention is that we've been very successful in embedding ourselves in the architecture of legal defense, of eviction defense in LA County, such that our current estimate is that between 11 and 12% of all the evictions in LA County are having that eviction responded to or answered via the Tenant Power Toolkit. And so again, it is our goal, it is our hope that we will be able to reach that same level of penetration, hopefully even more than that, in the various counties in the Bay Area. But again, for that, we will need tenant organizations, legal service providers, as well as other community partners who don't do housing as their first target, or they might support tenants going through an eviction just by happenstance because a tenant might be a member of their organization or they are an impacted community member. Just simply being able to tell them, hey, there's this toolkit that you can use right now to be able to prepare an answer, that could make the difference between them losing their homes in a matter of weeks, or being able to either come to an agreement that might be useful or more beneficial to them, or actually being able to stay in their homes. And so it's for that reason that we are building an infrastructure in the Bay Area. We want to have a Rose, who was on this call today for the Bay, who will be able to stand up workshops with our various partners in the Bay Area to be able to support that kind of infrastructure that she was just talking about, but also finding legal partners in the Bay Area who will help us expand e-filing outside of LA County. We have already made some very big strides in being able to do that possibly soon in Santa Clara County, but we are also talking to folks in San Francisco and in Alameda County about doing the same. Finally, I'll say one more thing about lawyers. Every single, about every few months, Rose will send out a survey to our users asking them about their outcomes. And I think it's very important to note here kind of what the information that we've gotten back from people. In about a quarter of all cases where people have responded to our survey, they will say that they were able to stay in their homes. Either the landlord pulled back the case, or they beat them at trial, or whatever. Ultimately, they were able to successfully evade the eviction altogether. In about a third of cases, tenants end up leaving because they lost their case, especially because they lost their case in about a third of cases. And oftentimes they lose their cases because they don't have a lawyer. And then in about a third of cases, tenants reach a settlement with their landlord. But again, oftentimes that settlement is to basically leave their homes. The important thing about those numbers, by the way, is that that is very determined by whether a tenant is able to find legal support or not. And so from the rates that we've been able to see in about I think it's like about 1/7 of cases, roughly that, tenants who don't get any legal support are able to stay in their homes. But about 3 times as many tenants are able to stay in their homes when they do find a lawyer, legal support, etc. So this is partially why I think it's important for us to remember that being able to build these kind of like links and infrastructure so the tenants do have somewhere to go after they file an answer is very critical. But it's also very critical to remember that even when tenants have lawyers, the law is against them. Tenant protections in the state are still far too weak. And oftentimes, even if they do have a lawyer, the law is not on their side on this, unfortunately. And so I think I just want to be able to mention again that the reason why we built this tool is not only because we want to be able to provide tenants with a little bit of a leg up in this kind of very, in this process, but to remind people also that the eviction crisis is real. It impoverishes people. And we need to do more to be able to get the number of evictions that people are facing statewide to 0, because ultimately it does destroy a lot of people's lives. I will pass it over to you now, Jordan. Sorry for that.
No, that was really helpful and informative, and thank you all to all of the panelists for this great webinar. Really informative. I learned a lot today. I hope the rest of the audience did as well. We haven't received any questions in the Q&A, but one audience member, Amber, had put in the chat that she's asked about extending the reach of the toolkit to Santa Clara, Santa Cruz, San Mateo, and San Benito counties. She's offering to help expand it with you all. I'm looking at the attendee list. I think she may have dropped out a few minutes ago, unfortunately, and she didn't leave her email address. I did find her on LinkedIn, so I can send it to you all afterwards. So I guess that leads to the sort of question is like, how should folks partner with the toolkits? What types of partnerships are you hoping to build?
Yeah, I think there are basically 3 types of partners that I can identify. Number one are, I think, very critically, the legal service community. We need a legal service community to really kind of understand that all the staffing in the world is probably never going to get them to the point where every tenant who receives an unlawful detainer will be able to file an answer via an attorney in that way. And so I think having the Tenant Power Toolkit as like a weapon of last resort, in critical moments, even a weapon of first resort, I think is an important mental shift we want to see with legal service providers. That is something that actually did happen, thankfully, in LA County, but it did take a little bit of convincing, basically, to get to that point. So there's that, but they're also with the legal service community. If we want to expand e-filing to other parts of the Bay Area, we're going to need to see legal service providers who are willing to basically do what ICLC did, what the Inner City Law Center did, to say, we're going to try to find resources jointly with you so that we can hire the staff necessary to be able to make e-filing possible. I am very heartened by what Cherry presented, showing that really with about 3 full-time clerks, a supervising attorney, and a coordinator, they are able to file roughly almost 1,000 electronically filed answers a month if they really needed to be pushed to their limits, which is an incredible amount of work that they can do. Most Bay Area counties are going to have far lower levels of volume, right? Or the volume of evictions are going to be much less than that because they are smaller than LA County. And so for that reason, it wouldn't really take that much support and buy-in from a legal service partner in, for example, Contra Costa County to be able to do that, right? So we need those legal service provider support partners. I'd say the second type of partner that we need are tenant organizations, organizations that are willing to work with tenants to walk them through the eviction process. In places where, like in the Bay Area, there might be a lot of support, and thankfully maybe a proportionally lower volume of evictions that we see in LA, that might actually be very doable for a lot of organizations to be able to help tenants walk through that process prior to the use of the answer toolkit, but then afterward, right? I should also say that we informally have a network of referrals for different organizations that we're able to say, hey, this tenant needs support. Can we send them to you? In different parts of the state, including in the Bay Area, we would like to deepen that roster of organizations that say we can help the tenant walk through that process. That's the second type of partner. And then the third type of partner, I think, are those who are a little bit more hands-on. We have organizations, nonprofit organizations in LA who informally will basically have a tenant basically use a toolkit when they have a problem. I have given presentations to healthcare providers where they've come to me saying, look, we have tenants occasionally who are having mental health crises or who are, literally dying of cancer. And they are also now facing an eviction. We don't know how to help them. What is the bare minimum that we can do? And I say to them, like, try to send them to these resources, these places, but have them file an answer with the toolkit. And so we've been able to get partners of that kind, just people who make other tenants aware that in the event that they need to file an answer, they can go here, they can file that answer as a kind of a minimum first step. So that would be like the third, type of partner, the outer layer of the onion, if you will, to be able to get the toolkit out there.
Great. Thank you. And I guess, well, before I go on, Princess, I see your hand is raised. I can unmute you and you can ask your question live, which I'll do after this. So I sort of the follow up to that is, to Amber's point is, are you planning to expand the tool to other regions?
Absolutely. And so again, we are currently working with a partner to make the Santa Clara e-filing kind of possible. It will take a few months to be able to implement. We understand that there are a lot of kind of hurdles that we need to jump through to make that happen, to bake them into the workflow, etc. We want to make sure that they're going to be well prepared to be able to do that. But yes, we are working on Santa Clara County. We are in deep discussions with the Eviction Defense Collaborative in San Francisco about expanding it there. Although the way in which that might be expanded will kind of depend on a further kind of like tech thing that we will try to figure out together. And we are talking to some partners in Alameda County about doing the same. Again, we would like to be able to find other legal service providers in other parts of the Bay Area who might be able to take that on. For example, in the North Bay, we don't currently have any North Bay legal service providers who would be willing to take on that work. If we can find some, we would love for them to be the kind of the North Bay inner city law center, right? To be able to provide that infrastructure for tenants in places like Sonoma County, Marin County, etc. So we can expand. We are ready to do that. We just need willing partners who are able to do that with us.
Awesome. Princess, I'm going to allow you to speak, so you should be able to speak now.
Oh, hello. Can everyone hear me? This is James, not Princess, but
Oh,
maybe I'm in a different Zoom account. Hi, I actually, I think one, I want to just offer, I work for the Regional Tenant Organizing Network in the Bay Area, and I can try to connect you to folks in what you're talking about. I think so. I can send you my email. But I didn't know. And then my question is around data privacy. How, unless I may have missed it, but I do think that's always the biggest concern with any tenant facing things is their data and how it's being managed and where it's going. So I'm curious, what are your security practices to protect tenants that are using this online platform to make sure their data is not going everywhere?
Before I ask Paul to answer the security question, I wanted to say, I know that Amber did seem to rejoin the call. Amber, if you can hear me, my email is in the chat. I want to take you up on that offer for kind of outreach about the Tenant Power Toolkit. My email is in the chat, and also for you right now, like anyone on the Q&A section, anyone listening, if you want to reach out to me about kind of working together to expand it, my email's in the chat. I'm happy to talk after this. But Paul, yeah, if you could talk about data security.
Yeah, definitely. No, thanks. That's a great question. And we follow the recommended practices for data collection and data storing. So all of our data is first of all stored in a secure way that is only accessible from our own servers networks. And so it's not publicly accessible. There, it's very resistant to attacks like cyber attacks or things like that. In terms of our data sharing, we have a pretty strict data sharing agreement where we don't share the data. We don't sell the data, really. We only share the data with our team internally and with Inner City Law Center, who's a part of our team, to do the electronic filings. So the only people that have access to view people who have used the tool and their data entries are people a part of our team or a part of Inner City Law Center. We do have a data request form that people can ask for support or for data request. That's not really used that often, and we kind of do it on a case-by-case basis if we want to share some anonymized data or if that could be a broader partnership worked out. The last thing I would say is that we ask for tenants' consent when they're filling out the tool if we're able to contact them about their case, but also if we're able to share their information with supporting organizations or tenant rights organizations who could help them potentially if they're in their area. So we do get that consent. We kind of have gotten that consent in advance, even though we're not actively sharing it with tenant organizations right now. But as we build out our partnerships in the Bay, that's something where, everyone that has consented to have their information shared, we can share it with our partner organizations and with kind of a strict data sharing agreement that this is data that we're not selling, that we're not sharing externally outside of our specific agreement. But does that kind of answer your question, or do you have more follow-ups based on that?
Yeah, I think that does. I think, do you all have that summarized anywhere besides the kind of consent form? Is I do think that is gonna come up over and over, is like, so it's secure between Inner City Law Center and Tenant Power Toolkit, but like who are the folks that are in that alignment? And as the collaboration spread, like who else will have access to it? Will Inner City Law Center have access to all the contacts that are in the Bay Area, right? And I think it's just like working with tenants, that's always such a big concern, especially when it enters their legal realm. And so I think the more there can be clarity around that infrastructure of security is really going to help more tenants buy into using the tool.
I will just clarify really quick about what Inner City Law Center has access to. So only the Tenant Power Toolkit team in our office, which is the staffing that I had talked about. So it's 9 of us total have access to this data. We have access to the backend, like I said, that we use for our electronic filing and keeping track of status and stuff like that. And the remainder of like all of the attorneys, anyone else who works for ICLC does not have access to that back end, and they actually don't even have access to like our folders and saved files. They don't have access to that in our SharePoint. So we like completely section off the rest of ICLC. So even if ICLC grows, for example, that doesn't mean that more people have access to this data. And I will just flag that even for reporting purposes, so we do get funding to do the electronic filing and the workshops. So even reporting to the City of Los Angeles and County of Los Angeles, we only provide anonymized information and only the information that the funder, the city and county require. So for example, it'll just be um, like things like case number and the name of the person and their contact information, like those will not be included.
And if I can just add, thank you, Cherry, for adding that. I should have specified more internally the dynamics. But also, yeah, I think that's a great point, and we should we have like a data sharing document, like agreement statement written, but we should really flesh that out and make that more public. So I think that's a task that I can take on. But also, to your point about if we expand, if we scale to the Bay or to other areas, will then Inner City Law Center have access to that data? That our desire and what we can build out, because this is a custom architecture we've created, is that we can actually separate these things where we have, tenants that are, however we want to define it, but tenants that are, in the city of San Francisco or in the entire Bay Area, are only visible, to the firms that we work with in the Bay. So if that's, a desire that we don't want to cross share this data, that's something that we can do. Currently, our only, established partner to have access to this data is through, through the tenant team at Inner City Law Center. But that's something that we would want to expand out. That's what we've thought about, and it's very easy for us to add that kind of separation as well going forward.
And so for the Santa Clara partners right now, right, we're talking to one law firm about them possibly helping with the e-filing. The idea is going to be they're just going to be able to see the segregated data for Santa Clara County and Santa Clara County only moving forward, because they are the ones who are going to be providing the e-filing capacity.
Thank
Right.
you.
And thank you, Prince, or I'm sorry, I didn't hear what your name was, but thank you for that great question. I don't have other questions in the Q&A. I had my own personal question, which also is a little bit out of the scope of this toolkit, since it's designed for tenants already facing eviction. But I had a question, for tenants who are living in unsafe or uninhabitable housing, and are considering withholding rent or might be at risk of eviction. Do you know of resources that can help them navigate and preemptively protect themselves? Is that something you think about adding to the toolkit in the future?
I don't know if Rose, you want to just talk a little bit about the kind of general resources. I have some thoughts, but I've talked a lot already.
Well, I wonder if Cherry wants to talk. I think the legal difficulty of doing that would be immense, because before there's actually any legal documents, then the kind of letter it might make sense to send, or the kind of protections that might apply to a tenant, would be so specific on the situation. There are some organizations that provide kind of like template letters, but in our experience, in those kinds of situations, they should really be working with their neighbors to form a tenants association, and should be really connected to an on-the-ground organization. Because once you're withholding rent, then you're opening up the risk of eviction, and that's, you don't want to take that risk if you don't have to. So people really need to be connecting to an organ, and there are certainly places where those organizations don't exist. And yeah, I mean, we hear all the time from people who are in really far-flung areas, who are in horrific situations, and there's, we search high and low for what to do to help them, and in a lot of places there's basically nothing. But I think the thing that needs to happen is building those organizations. I don't think those are problems that can be solved by having the right letter or having the right document. What people really need is people who can help them. But maybe Cherry has something to add.
No, I think you're exactly right, Rose. The two main things that people can do are connect with a community-based organization, or look for like an affirmative litigation team. ICLC has one. So, many legal services providers have some kind of team like that. They typically will only represent tenants where multiple units in the building are having this issue. But exactly as Rose said, neither one of those will really work for someone who is in Central California, rural areas in California, unfortunately. And as far as building it into the tool, it is more complicated. I think, well, first, I think it'd be a separate tool, kind of like the RFA tool that we have. But unlike evictions, where we have statewide defenses and a general template that local just cause and rent stabilization laws follow, there is so much variation, jurisdiction to jurisdiction, what causes of action and what statutes tenants have in bringing a suit against their landlord for failing to do repairs. Almost always my advice is the same, like it's like call the housing department, get an inspector, like build your paper trail, and then, try to find these legal resources. But in LA City, you might be filing a claim under Tahoe, under the tenant anti-harassment ordinance, for failing to do repairs, because that's something you can do under that ordinance. So anyway, it just varies so much jurisdiction by jurisdiction that creating a statewide tool will be more complicated than creating what we have for the answer tool, which is a statewide tool that is jurisdiction specific. But it's definitely really important and an interesting idea. And at least one thing that we have talked about and do still think about is if we could create something that does just draft kind of a demand letter, that might be, even if it's simpler, it might be more feasible. We do withholding rent, is always like, it's just a big risk. And while a tenant should have that right, and it is a defense that exists on the books that you withheld rent, for failure to do repairs. As we've talked about, for the past 2 hours, there are just many hurdles for tenants in the eviction process. There are many, many, many unsympathetic judges, and so it still can be very risky for tenants to withhold rent, even if they have good reason to.
Yeah, and on that, just I think people forget that whatever tenant defenses tenants might have, tenant protections tenants might have, these protections are not self-actualizing. They're not automatic. You have to be able to enforce them in some capacity or another. A city like San Francisco, Los Angeles, Oakland, Berkeley have housing departments or rent boards that are able to kind of step in and try to enforce these laws, although we should be very honest about the limitations of these enforcement mechanisms. But they at least exist. If you are in Alpine County, California, if you're in Amador County, California, if you're in Butte, these are not places that have that infrastructure. They don't have the same sort of enforcement mechanisms. And so what ends up happening is that the court ends up being the site where you have to enforce your rights. So you might have these protections on the book, but in reality, the only forum where you can actually try to raise them and use those defenses is a court. And of course, the court, for the reasons Cherry just stipulated, isn't really a propitious place to do those or to raise those defenses, right? We have judges that are unsympathetic. We have legal costs. Even if you're trying to self-represent, the court process is super arcane and Byzantine, right? So it's very difficult for people to navigate that process on their own. So that is a reality of that tenants constantly face in the state. Even if we were to have, though, a legal right to counsel statewide, you would still have a situation where tenants would have to do a lot of preparatory work just to be able to ensure that if they do get to trial, they can exercise their defenses properly. And so ultimately, as Rose mentioned, I think, and Cherry emphasized, really it's that need for on-the-ground community-based support. I think that is the kind of stuff that we really need to build, no matter where we are in California.
Great. Thank you all for that. And I think that brings us to the conclusion of today's event. Thank you so much, Rose, Paul, Renee, Cherry, and thank you everyone for attending. This was a thoughtful and informative session. If you'd like to stay connected, Renee put their email in the chat. And if you'd like to stay connected with Partnership for the Bay's Future, you can visit our website at baysfuture.org. I'm going to put that in the chat again. And you can receive updates on our events, resources, and news on all that we have going on. Otherwise, thank you again, everyone, for attending and for being a part of today's event. Have a great day.